Sounds great. Thank you so much for hosting us. I love talking about transition rights because when we talk about special education generally, the idea behind special education is not just supposed to be procedural safeguards. It's supposed to be about changing the life outcomes of kids with disabilities. And that's really what we get to when we get to talk about transition. I'm going to be a little bit ambitious today and try to talk about special education, a little bit about the transfer of rights, guardianship and alternatives to guardianship, and a little bit about vocational rehabilitation services. I know that there will be probably opportunities in the same series and in other venues to go into more depth on those later two topics, but they're also interrelated that I wanted to try to cover all three to some degree as a part of today's topic. For those of you who aren't familiar with Disability Rights Texas, we're the legal protection and advocacy organization for the state of Texas. So by federal law in the 1970s, an independent organization was established in all 50 states to protect the legal rights of persons with disabilities in that state. So we're that organization for the state of Texas. I supervise our education team here statewide. We also have other teams that do healthcare rights, employment, and housing and transportation discrimination, the rights of people in institutions, and vocational rehabilitation. And so those are the main issues that we handle. At the end of today's presentation, you'll see our intake line. So if you're someone who, beyond the information you received today, is really looking for an advocate or attorney in your case, feel free to request our services online at drtx.org or using that intake line. I want to talk to you a little bit about the screen you're seeing in front of you now. This is actually the first page of our organization's transition guide. And a few years ago, we received the funding from the Hogg Foundation for Mental Health to create our first transition guide that tried to be really focused on youth themselves. So I often get asked to do presentations much like today that are targeted at parents and caregivers, but we really have tried to improve our resources and our reach to youth themselves where possible, because such a big part of transition in advocacy is that move from the parent being the primary advocate to the move to the young adult having to at least become comfortable talking about their disability a little bit, requesting accommodations. And this guide that we've developed covers all the material that we're going to cover today, but it also covers things like housing accommodations and employment accommodations and goes a little further in those areas than we'll be able to today. So I encourage you to check it out. It's available for free on our website at drtx.org. So without further ado, let's get into the discussion about special education, which is, of course, the area that I work in most. And, you know, different than an overall overview of special education, what I'm really going to do today is talk about what are the transition rights within special education and how do you improve transition services. And so all of the laws that we are focused on in transition come from the Individuals with Disabilities Education Act, or IDEA. One thing to know about is that there are no transition rights in Section 504. And so, you know, children with disabilities, some of them are served in special ed, some of them are served in 504. The rights we're going to talk about today, about the school's obligation to prepare a student for life after high school, are rights specific to special education. So I just want to give kind of a brief history of special education so you'll kind of know what it is. You know, back in 1972, we had a situation where in most of the country, public schools were denying all access to schools for children with developmental disabilities. We had two cases that challenged that, and the resulting settlements from those Park and Mills cases resulted in the IDEA, the law that we now have for special education. That same year, Section 504 was passed, and then in 1982, we had our first Supreme Court case where schools were basically arguing that the laws we had passed only entitled students to procedural safeguards, meaning 5 days notice for the ARD meeting or who the actual ARD participants were. The Supreme Court rejected that argument, and it found that actually you have a right to an education that leads to some benefit, right? That you have a substantive right to a quality education as well. Unfortunately, they also said that Amy Rowley didn't get every service that the parents would have believed she needed. Specifically, the Supreme Court in that case did not provide that Amy Rowley got a sign language interpreter because without one, she was still making good grades in school. Come forward to 1990, the Americans with Disabilities Act passed. This is so important because when the Americans with Disabilities Act passed, it created really the generation of community living. It enabled access to places of public accommodation. It also potentially challenged some of those limitations of the IDEA in areas like sign language interpreting because it has effective communication provisions within the Americans with Disabilities Act. And then just in 2016, the Supreme Court ruled in the decision of Andrew F. that the low bar that many courts were applying to special education cases were not good enough. We're actually just yesterday at Disability Rights Texas, we're honored to file an amicus brief in a Fifth Circuit case that's arguing about what Andrew F. means for us here in Texas and in the Fifth Circuit more broadly. So I think it's important to know that at the time the IDEA was passed, the congressional findings were that children with disabilities can be made more effective by having high expectations, ensuring access to the general curriculum, and meeting developmental goals set for students. This prepares students to lead productive and independent adult lives to the maximum extent appropriate. And I include this here just so we recognize that it was the intent of special education to address long-term outcomes for children. So when we talk about the sources of special education law, IDEA itself is federal law. We also have state statutes, which are found mainly in chapters 29 of the Texas Education Code. And we also have commissioners' rules that address special education rights. These three sources of law are all made available in a free resource that's on the next slide called the Special Education Side-by-Side. For those of you who are really interested, it can be a little dense because it is the actual law, but all three sources of law are together side-by-side by topic. So you could look up a subject like transition or like discipline and see what the federal law, the state law, and the commissioner's rules have to say about that topic. And that's available for download on the TEA website. Additionally, we have our office's IDEA manual. It keeps getting longer and longer because we revise it after each legislative session to address important reforms for that legislative session. Still, we find it to be the most parent-friendly special education resource in our state. It's also long because it contains a lot of draft letters that parents can use to request their records or request an ARD meeting or an independent assessment. And so please take advantage of that free resource as well. So I just want to talk for a minute. I mentioned that the rights to transition services only apply to children who are in special ed and not 504. So I want to just pause for a minute and say, who is eligible for special education in case any of you on the phone, either your child or someone you're working with may not have that eligibility yet. So special education requires that a person have a disability and a need for specially designed instruction, which is actually how we define special education. And so think about if I were a student who used a wheelchair, but I had no other impairment, I would be protected from discrimination by Section 504, by the Americans with Disabilities Act, but I wouldn't necessarily need specially designed instruction. So for that reason, I wouldn't be eligible for special education, and I wouldn't get special transition rights. So when we think about what is an educational need for specially designed instruction, it's not just academic, it is also behavioral. So what we're really thinking about is if I'm a student with a disability that because of my disability is struggling academically or behaviorally, I may be eligible for special education services. So, you see then that all of the students who are in special education are also protected by the Americans with Disabilities Act and 504, but it's just that smaller group who need specially designed instruction that are protected by special education law. So transition services that students who are in special education are entitled to are a coordinated, and this is the actual definition from the law, a coordinated set of activities that are results oriented, facilitate movement from school to post-school activities, and that are based on a child's needs, taking into account their strengths, preferences, and interests. And so one thing I think that's interesting to point out about this is we'll see later that this child's voice really becomes quite important in ARD meetings dealing about transition. Because very often I think schools and sometimes parents can be distracted by what the school's transition program, quote unquote, looks like. So maybe the district you're in is a larger district who has a transition campus for special education where they have 4 programs that do 4 different vocations. Well, that doesn't mean if your student is interested in something different that those 4 vocations don't help them with, that they need to go into one of those 4 programs just because that's what the school has. It's really supposed to be individualized determinations. And it also are a coordinated set of activities. I think all too often we see transition plans that look a lot like a page where they just ask the student what they're going to do and then don't necessarily offer any services to help them get there. Transition services are supposed to be actual services. They can include, transition services can include instruction, related services, community experiences, goals for employment and adult daily living activities, and can include functional vocational evaluations. So I want to tell you a little bit about what a functional vocational evaluation is. All services in special education are supposed to be evaluation driven. So if we're determining how much speech therapy a child needs, that's supposed to be based on assessment. What behavior supports a child needs, that's supposed to be based on assessment. That's true in transition also. But if there was one area where we rarely see schools take assessment seriously, unfortunately, it's probably transition. And so what we see a lot is schools relying on informal assessment, where they maybe just do a screener to see what the students' plans are in different areas, but maybe don't use any real standardized assessment. There are standardized transition assessments. For example, you might take an an aptitude exam to see what kind of careers line up with your personality and strengths. But if you're a student with an intellectual disability that might have difficulty generalizing what you might enjoy or be good at on a traditional interest and aptitude exam, a functional vocational evaluation is probably more appropriate. In a functional vocational evaluation, you would actually try trial work experiences in different settings and see how they go. And that can give information about what your interests and aptitudes and strengths and needs may be. So transition services under the IDEA begin before a child's 16th birthday. But this is one of those areas where we can be proud that Texas exceeds federal standards. And so in Texas, transition has to start by the age of 14. And what that means is that ARD meetings from the child's 14th birthday on, transition should be discussed at each annual ARD, and services should begin. Now, the reality is, in so many areas of transition, we're trying to develop skills that hopefully we've been working on before the age of 14. So, for example, self-determination. We want someone as an adult to be as independent as possible. We don't start introducing the idea of expressing preference and making your voice heard at the age of 14. We do that much earlier. Another state law that we have related to transition in Texas is Ricky's Law. And Ricky's Law is a law that makes clear that there was a problem with students being able to stay in school till the age of 22 to keep receiving transition and special ed services, but feeling a little isolated by the fact that their peers that they had been going to school with may be graduating at 18. And so what Ricky's Law does is it allows school districts to designate an employee to work on transition and employment services. And it also makes clear that a student can walk in a graduation ceremony with their same age peers and receive a certificate, but continue in school past that time to continue receiving the transition services they would like to up until the age of 22. So transition services under the IDEA have to consider a student's preferences and interests, their individualized transition plan, and they have to be delivered in the least restrictive environment. So, the least restrictive environment refers to the placement continuum we have in special ed. So on the one hand, we have students who are in general education, and then on the most restrictive end, we have residential placement. In between the two, we have separate classes and separate schools. The reason I think that it's important to remember that the least restrictive environment applies to transition years is that especially in larger districts, there can be an inclination to build a separate campus to keep all of their transition and 18 plus programs. And that, I guess on the one hand, can create an opportunity to have more specialized programs for people with developmental disabilities. But a lot of times those separate programs prepare youth for separate employment or segregated employment, which isn't necessarily what the goal should be, right? If a person with a disability can work alongside of non-disabled peers and make a competitive wage, then it would be better or preferable to try to prepare them to work in settings that are already a mix of students with and without disabilities. I think we've got a long way to go to keep making that case child by child and getting people to think in an individualized manner of how a person can be served on a regular campus and still be receiving meaningful transition services and vocational opportunities. So students are allowed to participate in ARD meetings even before the age of 14, but once you're discussing transition, the law makes very clear that there's a strong preference for the student to participate in the IEP team meeting unless all members agree that that's not appropriate. And if that's not appropriate, there still has to be another tool to get the student's preferences to be considered by the committee. Probably in no other area is it more clear that there shouldn't be anything about us without us. If we're planning for what a child's life should be when they're an adult, what they're going to be interested in doing for a career, we really have to hear from them about what their interest is. So it's really important to engage other agencies in transition planning. One of the most challenging things about transition is that there are so many pieces to it. It's why our agency tried to come up with the transition guide that walks through all the basic information you need in college and Social Security and healthcare, because all of these agencies have different transition requirements. They all have different eligibility. They all start at different times, and it can be really confusing. The law attempts to make the school one kind of clearinghouse to try to coordinate the many areas of transition, but I think we all know that doesn't work very well. I had seen in the chat even before we got started today that one person had said, I hear that districts invite people to attend the meetings, but they don't come. What can we do about that? I think probably the agency that we most want to attend our meetings is the Vocational Rehabilitation Service Office or the Texas Workforce Commission now. It's no longer DARS, it's the Texas Workforce Commission. We'll talk about that a little later. I think that one thing that is particularly important to keep in mind is that these agencies don't have enough staff, and if your child is not already receiving services from the Texas Workforce Commission, if you haven't done an application, if the counselor doesn't know your child, then even if we advocate zealously to get the agency at the meeting, all they're going to be able to do is give a brochure about their services and encourage you to apply usually. What we find to be most useful in getting them to the table is to encourage our clients to go ahead and do an application for services. And when you apply for services, you are asking for help getting a job. And so go ahead and, call in and say, I want my, son or daughter wants help finding a summer job. And so we're calling and requesting assistance for that. They're going to go through a several-month process that we'll talk about later. But once they're assigned a counselor who knows more about their needs, maybe has done some assessment, then all of a sudden it's much more likely that you should be able to use that, to encourage that counselor to attend an ARD meeting, to even schedule around that counselor's agenda, because now they really have useful information to engage in the meeting. So I personally don't usually fight the fight to get a vocational counselor to attend a meeting unless they know the child, because that's where it becomes useful. And I think that's where you're going to have your successes. So different agencies that can be invited to participate in a transition ARD are the Texas Workforce Commission, Vocational Rehabilitation Counselor, the local mental health and intellectual disability authorities, independent living centers, Medicaid waiver case managers, and the Department of Blind Services. I'll tell you some of the reasons it can be important to engage some of these is that very often there are few people in any of these systems who really understand the other systems well. And the reason that can matter is because decisions can be made at school based on false assumptions about what other agencies can and will provide. And so one of the things that I'll probably warn you about a few times in today's presentation is to be wary of the push to graduate a child early. If you have a child with an intellectual or developmental disability who's entitled to stay in school till 22 and is not doing grade level work and isn't going to be able to enter a college where they're doing credit bearing work, take advantage of the free education services that are provided in public school till the age of 22. Sometimes when I see public schools encouraging kids to graduate at age 18, what they're really doing is saying, well, it's time for you to go to the group home and use the day hab during the day. One, that's often based on a misunderstanding about what day hab makes available, right? A lot of times the school personnel who are making that recommendation may have never visited a day hab. They may know nothing about what day hab resources are in the community. We saw this last year for a client who the real reason the school was trying to get the child to graduate early is that the behaviors were really complex. The behaviors were so complex, in fact, that we were pretty skeptical that there was any day hab in that community that would accept the child or allow them to stay and participate in their program. So I think they were setting the mom up for failed expectations, not only around the quality of programming, but around how realistic it really was for this child to move to a day hab setting anyhow. So I want to just go over some practice tips for advocating for appropriate transition services. So first, request formal assessment. And so formal assessment can include transition assessments. Many districts don't really know where to start with transition assessments, but really think about all the areas of transition where you may be concerned. For some people, that's going to include looking into, I would love to see more self-advocacy goals in transition plans. So where is the student in understanding what their disability is and what it means they need and being able to talk about it or ask for an accommodation? Those are great transition goals that we see very little. You know, I think that a lot of people talk about money management and financial skills. I think that's good and important, but I actually think it's the area that schools across the board seem to be a little stronger in. Most IEPs for a transition age youth that I've seen, at least at some point, have included some money management goals or developing a budget or doing that as some kind of activity in a class. But it's very rare that I see transition goals look at healthcare advocacy. So does the person know how often you should see a doctor or how to make a doctor's appointment or how to prepare questions you might have for your doctor or ask questions of the doctor? Does a person know how to fill a prescription? These are all parts of independent living in that important area of decision-making related to healthcare. So when you think about transition assessment, think about what are all the areas where this person may need to develop stronger skills to prepare for life after high school. And employment is a piece of that and perhaps the most important piece, but healthcare decisions and self-advocacy are also important parts of looking at a person's transition-related needs. Person-centered planning can be a great process. Going into it in detail would take a full presentation, but it can be especially useful for people with more significant disabilities who would struggle to use maybe to use words to tell us about their interest for their life after high school. So it's a wonderful process that I would encourage you to look into, especially for those people with more significant disabilities. Consider new requestment at the end of high school to use for post-secondary and employment purposes. Here's what I mean by that. In special education, the assumption should be that you would get a full individual evaluation with all new assessment every 3 years, unless the ARD committee agrees that that it's okay to skip the assessment or do just what's called a read, a review of existing evaluation data. So very often at the very end of high school, assessments cost districts a lot of money. They feel like one of the primary purposes is to determine if the child's eligible and to know the child's needs. A lot of times at the end of high school, when that 3-year evaluation is due, the school district may feel like, we already know that this child's eligible. We're not contesting that. We already feel like we know them really well. There's no reason to do formal assessment in your senior year. As a parent, especially if you're planning for that child to go into college in any way, I would really ask for updated assessment. And I would say updated assessment just because it's important to see how the child's changed and developed to make plans for that last year of school. But the reality is you should have another purpose as well. And that's that many of the programs that you will try to become eligible for or need evaluations for may not pay for that assessment, and you will need it to be current. And so, for example, if you're going into college, you will often be asked for an assessment that's no more than a year old. You might be able to get the Texas Workforce Commission to pay for that assessment or do that assessment, but otherwise, it's really going to be out of your own pocket. A college wouldn't have to pay for disability-related assessments as a part of the accommodations they provide. But if you have a new copy from your senior year in high school, it's ready to go. Similarly, you'll be applying for adult SSI right before a child becomes 18. So having new assessments also helpful in that process. So whenever you disagree with an assessment that is done through special education by the school district, within 1 year of that time the school did their own assessment, you have the right to request an independent evaluation at the school district's expense. So this is really a second opinion when you disagree with what the school's done, and you get to choose a qualified evaluator of your choice, and the school must agree to pay for the assessment unless they take the unusual step of filing a due process hearing to defend the assessment they've already conducted. That happens occasionally, but it's quite rare. The vast majority of school districts would rather pay the few $1,000s for the independent assessment than the more expensive litigation cost of a hearing. In the area of transition, school district evaluations tend to be particularly poor. I've yet to hear of a case where a school district denied a request for an independent transition assessment. So ask for the school to do the kind of detailed assessments we've been talking about, but if they don't, consider seeking an independent evaluation. So this just says that when you request an independent evaluation, and you can reference a form letter to do that on page 38 of our IDEA guide, the school either has to pay for it or they have to file the due process to defend their existing assessment. So engage the student. You know, engaging a student in transition is so important. As we said earlier, nothing about us without us, but I'll say it's not just about engaging them in the ARD process, though that's a first step. But sometimes the student and the parent are going to have potential areas of conflict. You know, one of the most common that we see is about whether to stay in school. So at the age of 18, the parent knowing that they may not be that great and that maybe they don't have other options to care for the child, really wants that student to stay in public schools and work on their transition skills. But that student may be fed up, especially if things haven't been going that well the last couple of years, especially if they feel like they're working on the same things they've been working on for many, many years. So sometimes really digging deeper about what motivates the student and interests the student advocating for those services that get the student into the community or let them have a real work experience can motivate a at-risk student who might otherwise be encouraged to drop out or end their education earlier than they could. It also teaches self-advocacy skills for life after high school. Yes, as we'll talk about a little later, there are options for the adult student to sign a power of attorney so that the parent can keep advocating in ARD meetings, but it's so important to build those self-advocacy skills for college, for later work, because that person's going to have to become comfortable at some point in discussing their disability and requesting accommodations, and you get comfortable by practicing. And so preparing that student to even just think of one thing that they really want to share with the ARD committee and helping them practice their words around that and maybe writing a statement that they want to read to the committee. It's a really important exercise to prepare for a transition ARD.
Dustin, we have a question.
Yeah.
We have a couple here. The one relates to what you were just talking about. Can a school place a cap on what the fee is for the independent assessment? They
can place a reasonable cap, but the cap can't keep the parent from being able to get an IEE. So if in that community there are independent assessments in the area of transition commonly available for $1,200, but you pick the most expensive person at $4,000, they don't have to pay $4,000. However, what happens sometimes is a school may say, our cap is $500, and they provide you a list of evaluators, though you can choose any qualified person, whether they're on that list or not. But I encourage you, if you found someone, especially who's not on their list, who they're saying is too expensive, call all of their evaluators and ask their price. If they won't give you that information, do a public information request to the district about the receipts and contracts for evaluators with that type of evaluation in the last 2 years. What you'll often find is that the district may have been inconsistent in who they pay what amount of money to. And so I think districts are allowed to have reasonable caps, but they should be treating people equally and fairly and not having a discriminatory practice around who they'll pay what price to. Often when you play hardball and you dig a little deeper into requesting what they've paid to other people, they end up approving your request.
And one other question, does each school have their own form of a vocational evaluation?
Honestly, what I see most commonly are what I call screeners, which is just some kind of form where they're asking the parent questions and the student questions. And it may go like, where's the person going to live after they graduate? What are you planning to do? And that's not a bad place to get started. The problem is that it's not good enough if the answers on there don't give you the information you need to plan for the student's transition. So I had a case one time on behalf of a young man with an intellectual disability and dwarfism who was being graduated early at 18. And when we reviewed the transition assessment or transition plan, it simply said that his career would be that he was going to be a professional football player. And all of the members of the school-based members of this team had just applauded and said that they were very excited to go see him play professional football. Now, this young man had never played football even in high school, much less had any plans to become a professional football player. And I don't want schools to be dream killers, but I do want them to help identify reasonable goals and steps to get there. In this young man's case, he was so easily motivated by other things that related to football, but no one even bothered exploring. Would you be interested in working any other job at a football stadium? Would you be, even for recreational interest? He's this interested in football, but no one had even explored whether there was a community football league that would work with a person with a disability to begin playing and building friendships. So nothing was done with that useful information about his interest that made it kind of realistic or developed into a service or a plan for this young man. And so that's why we're looking for real assessment. We don't want people just writing down what the student says and calling that a plan. That can be a first part of an assessment, but if the student isn't able to identify a realistic career option, then having a real assessment is how we may be able to identify something that matches the student's strengths and interests.
Okay, we'll go on. Is this the next slide?
I think we can go another slide.
Okay.
So, one of the things we're going to talk about in a little bit are what are the options around alternative to guardianship. And one of the things that's so important is we don't start making decisions at the age of 14 or 16. So we want to be sure to build decision-making skills into IEPs at a young age. Be sure that transition goals and services build those skills in all areas, including healthcare, relationships, living options, finances, career. So, the other thing I have to say is beware of the push to graduate a student early. Students remain eligible for FAPE until the age of 22 unless they meet the requirements of a regular diploma. So another thing is a lot of times schools may generate enthusiasm in a young person with a disability about getting to graduate at 18. Oh, we have good news for you. You're going to get to graduate this year. And it's hard when that youth gets really excited to kind of say, oh, well, actually, we want you to stay in school 3 or 4 more years. But the truth is that it's often good to stay in school for 3 or 4 more years. But if they have met their graduation requirements, we can really start getting creative around what transition may look like. They don't have to go a full day. Maybe they spend a half day doing some academic skills or related services. Then maybe they get to go have a work experience for the afternoon, just for example. Some school districts have partnerships with community colleges where maybe you're spending a part of your day in the high school and a part of your day in the community college. We also meet a lot of families who maybe agreed with the plan to graduate at 18, and then they move forward and find, oh, everything in our transition plan said we were going to go to college, but I didn't realize that because my son or daughter had been doing modified work, that they weren't going to be able to enter a community college credit-bearing program, that they're going to be doing remedial non-credit-bearing classes at the community college. And I could be doing that in the high school for free, right? And that's exactly right. And so one thing to keep in mind about that is that even if you have graduated with a diploma, but it was based on making progress on your IEP, but you still weren't passing the regular state assessments and you were receiving modified work, that student is still eligible to re-enroll at school and ask for transition services. Now, I'll go ahead and warn you that few registrars in the state are probably likely to know that, but I promise I'm right. So try to do it, get them to document in writing when you're turned down, and then call DisabilityRights Texas.
And we have another question here. I think this applies to this particular issue. Does this only apply to Texas or other states as well?
So almost everything that I've said today would apply to other states as well. However, I will say that we have several laws in Texas on transition that are state specific. So starting transition services at the age of 14 is state specific. The law about the student having the right to walk in graduation with their same age peers and continue in school is state specific. What is considered graduation for purposes of ending your eligibility for special education is actually in our state rules here. I think it would be similar in many other states, but I have to acknowledge I'm only licensed to practice law in the state of Texas. So it's a combination, and it depends what piece we're asking about.
Okay.
So behavior, we could have a whole presentation just on behavior, but I will say for a lot of transition age young people, that's main need is in the area of behavior, it can become challenging to get to work on these other goals of transition and healthcare and other things that the youth may be needing help in as well. Make sure that if you're struggling with behavior, that there's a quality functional behavioral assessment. That's the evaluation that's used to determine the cause of behavior and to develop a behavior intervention plan. I'll tell you, so often with these transition age youth that schools feel like they can't do anything else with because of the behavior. When I look at it, the functional behavioral assessment that has been done is really low quality. And, oh, I just got to notice my computer may be updating and wanting to restart. I will have to stop that from happening. So anyhow, that is something that, that you have to be aware of. And quality functional behavioral assessment should include observation by the assessment professional, preferably a board-certified behavior analyst, at least a PhD psychologist. If they're just filling out checks boxes at the ARD meeting, that's not the kind of functional behavioral assessment you're looking for a child who's exhibiting complex behaviors, and it's a good opportunity to request an independent FBA. So if a student is being removed for 10 days or more, there's special protections where the ARD committee has to, by removed, I mean suspended or expelled. The ARD committee has to come together and ask, was the student's conduct caused by their disability or a result of the school's failure to implement the IEP? The answer to either question is yes, they have to do a new functional behavioral assessment and a new behavior intervention plan. The answer is no, regular disciplinary procedures can be applied. There is an exception if guns, drugs, or serious bodily injury was involved, but that's in less than 5% of the cases, so I don't worry too much about it. Schools are also required to provide a free appropriate public education even during long-term suspensions and expulsions, so their needs still need to be met even if they are going to be sent to an alternative school. So conflict resolution. If a parent or student has disputes with the school on any of these issues, they have several options. They can file a TEA complaint, they can request mediation, or they can file for due process. So our hope is that most issues can be handled at the ARD table. If a parent or the adult student makes a choice to disagree at ARD, then they can always have reconvened within 10 days. And hopefully during that 10 days, people are able to reach a consensus. But if not, if it's a clear-cut issue, a TEA complaint's a simple letter complaint. We have a handout on how to do it on our website at DisabilityRightsTexas.org. Mediation is free. It allows an independent third party to come in and in a confidential setting, try to work disagreements out between the parent and the school. And then due process is really the most serious conflict resolution. It is a form of litigation, and that form of litigation does not require you to have an attorney, but it's very challenging to do without an attorney. So I would encourage you before taking that step to at least reach out to Disability Rights Texas and other organizations and see if you don't have a chance of having representation in making that choice. So those are the three options that we just discussed. So I want to pivot here a little bit to the young adult taking charge of their decisions, and that's in the ARD process and in other settings. At the age of 17, at the ARD meeting, the school has to begin notifying the family that the student will become their own decision maker in 1 year, unless the parents have taken guardianship or someone else has become legal guardian of the child. For a lot of years, it was assumed that that's just one more thing that especially parents of anyone with a developmental disability needs to do before the child turns 18. We have a whole new way of thinking about that right now. We've reformed guardianship laws in Texas. We have longer presentations on just this topic, but suffice it to say today that if you have a young person in your life who's able to communicate their wishes in a basic way, who's able to communicate preference of what they're interested in or not interested in, you should really be looking into alternatives to guardianship. So At the age of 18, it is true that the student, if you don't have guardianship, will become their own decision maker, but the parent can still be invited to participate in the yard and guide the student, help the student out, and support them. One of the ways they can do that is, of course, at the important decision at the end of whether the student should check disagree or agree. So the notice of transfer of rights should go to the parent and the student. And now Senator Zaffirini passed a law this last year that in Texas, it says that instead of only providing information at the age of 17 about guardianship, schools also now have to provide information about alternatives to guardianship like supported decision making. I am really worried that my computer is going to log me off and I don't have, it's not giving me a delay button. I don't know. We will see what happens. Options for educational decisions. 18-year-old students who have the capacity to understand that they want their mom or dad to help them at the yard meeting can sign a power of attorney for educational decisions. It can be as broad as or narrow as the situation requires. So it could just be for education, or it could be for education and banking and other issues as well. Guardianship is the most restrictive way of making decisions for an adult with a disability. It should really be reserved for extreme circumstances far more than it has in the past. The main thing to keep in mind, I think, in determining if your child may need to go down the road of guardianship or whether less restrictive alternatives are a good option is, will they have the ability to consent to non-emergency medical care? So do they have the ability to express, yes, doctor, I would like that, right? Are they able to communicate that they want you to make decisions for them? Because they can sign a medical power of attorney if they can at least communicate. If I were to ask them questions like, do you want your mom to help make doctor's appointments for you? Do you want her to go to the doctor with you? Do you want her to help communicate with the doctor what's going on with your health? If they can answer yes to questions like that, then really you should be looking into less restrictive alternatives to guardianship, like powers of attorney and supported decision making. So some of the alternatives to guardianship, supported decision-making agreements are fairly new to Texas. They're basically agreements that say, I want my mom, dad, or my friend, whoever it is I pick, to help me make decisions. And that means I'll still make my own decisions, but they can help me decide what it is I'm wanting. So they can help me weigh options and understand the decision that's in front of me, but I still make it for myself. A power of attorney or a durable power of attorney is something the adult with a disability would sign to allow someone else, like a parent, to make decisions for them even in their absence. And so while the person with the disability would have to be present with the supported decision-making agreement, they wouldn't have to be present with the power of attorney. Medical powers of attorney are just for medical purposes, and durable powers of attorney can be for every other issue except medical issues. Joint bank accounts are also a great way to provide support to an adult with a disability. You can help move the money between checkings and saving to give them some financial independence, but also that support. Rep payees allow you to register to manage your child's Social Security. So these are all alternatives to guardianship that are less restrictive and don't take away the person's rights to make decisions for themselves. So I think we can move, I think I summarized this already, but we are in Texas the first state to have a supported decision-making law. The individual with the disability does have to be able to understand the decisions and be able to communicate that they want the supporter to help them with those decisions.
Sorry, I'm trying to email your boss.
The
computer doesn't stop.
I am really nervous about it because it says I have 6 minutes and it says restart or hide are my only options. I don't see an option to like do something.
We'll just be patient and wait for you to log back on. I don't know.
Okay, so supporters cannot make, so let's move on a little bit more.
Okay.
So changing topics a little bit, vocational rehabilitation services. So So many of you will probably still hear people talk about this kind of support getting a job being DARS, because that was the agency that was long in charge of this service. But a couple of years back, the agencies were redesigned, and vocational rehabilitation services are now within Texas Workforce Solutions. So vocational rehabilitations helps Texans with disabilities prepare for, find, and keep jobs. They provide individualized work-related services like job counseling, training, and assistive devices, and they help students plan the jump from school to work. The individual has to have to be eligible, they have to have a physical or mental impairment, which is a substantial impediment to employment. And they have to need services to prepare for, secure, retain, or regain employment. And they have to be able to benefit from those services. Social Security, disability, and SSI beneficiaries are presumed to meet criteria for services, and VR services, but you have to keep in mind that VR services are not considered an entitlement program. So that means that if they're running low on resources, if they don't have a worker at your ARD meeting, there's not a lot you can do. It's not an entitlement to have that service.
We have a question in the Q&A box.
Sure.
My son is 15. He always refuses to accept his diagnosis. What if he refuses parents to make decisions for him while he can't make good decisions at 18?
So, you really have to get into and explore what are the types of decisions that you fear they'll make. One of the things that can be challenging is that some of the things that parents are understandably worried about their young adult deciding may be the case whether or not you get guardianship. So for example, if you're worried about a behavior of not taking a medicine, an aggressive behavior of having sex, behaviors aren't changed by guardianship. So when young people are choosing or not choosing or involuntarily engaging in behaviors, they're not thinking about what a court has decided or hasn't decided, right? And so you're still having to manage those difficult, complex behaviors through counseling and behavior intervention and parenting skills. And that's not going to be easy with or without a guardianship. Yes, a guardianship allows a parent to make the ultimate decision on where a young person lives, but forcing a person to live in a place they don't want to isn't an easy task either. And so I think one of the things that can be challenging is just recognizing kind of the pros and cons of both having a guardianship and not having a guardianship, and understanding perhaps some misinformation about, guardianship fixing a lot of these complex issues that are going to remain complex whether or not you go that route.
Okay.
So there is a right to complete a vocational rehabilitation evaluation. Eligibility has to be determined within 60 days unless everyone agrees to an extension or the client experiences a trial work period to determine eligibility. So one of the best things about VR is that it's not an entry-level employment program. It's meant to assist individuals obtain employment that's consistent with their unique strengths, resources, priorities, concerns, abilities, and capabilities. This is a change from how it used to be, and you may encounter barriers getting these services, and those are great cases to call DisabilityRights Texas about. So you get an individualized plan for employment. So instead of the IEP you had in school, you get an IPE. It spells out your vocational goal, the responsibilities of the client and the counselor, the services that will be provided, often by a contract agency. So it will also say who's going to provide the services, when they'll be provided, and how progress will be evaluated, and the timelines for completion. It has to be signed by the client and the counselor. I'll warn us, my computer's saying 1 minute, so let's just get as much as we can and then I'll log back in.
Okay. We'll be patient.
So VR services can include the assessments, the counseling and guidance, job placement services, interpreter services and readers, personal assistant services while receiving vocational rehabilitation. They can also include training and the purchases of tools, materials, and books, the tuition for vocational training and other post-secondary education. There has to be a maximum effort to secure other grant assistance from other sources, and you have to take Pell Grants, but you don't have to take loans before VR would pay the rest of the cost of an educational program. It can include help with occupational licenses, tools, equipment, and initial stocks and supplies. VR services can include the diagnosis and treatment to reduce or eliminate impediments to employment.
And there he goes. We will wait for Dustin to log back on. If y'all will be patient, one moment.
Okay, I think I'm back.
Yeah.
So did everyone feel like you got a little bit of break to process all we've gone through? So some of the categories of diagnosis and treatment could include things like corrective surgeries, therapeutic treatment, the diagnosis and treatment of mental or emotional disorders that could be a barrier to employment. The thing to keep in mind about VR services is all of these things have to be related to the goal of employment. And so, for example, I don't primarily work in the area of vocational rehabilitation. We have other staff in our office who specialize in it. But in my school advocacy, I might tell someone, hey, it's going to be really helpful for you to open a VR case because they may do a better functional vocational assessment than the school would even know how to do if they tried. Well, you can't call VR and just say, I want your assessment. You have to call and say, I want help getting a job, and the assessment's going to be a piece of that service that's going to lead you towards getting a job.
Quick clarification here from someone. Having worked in higher ed, I would like to clarify, have to take Pell Grants, what that means. The student must apply for the Pell Grant, but if they are turned down, they can still apply for VR services. Reasons for getting turned down may be the parents make too much money to qualify. A parent may have a criminal background, or a parent may not have filed taxes.
Right, so what I'm saying is if you are awarded a Pell Grant, you would have to take that Pell Grant, if you are awarded one, before you would be eligible to receive supplemental money from VR to pay for books or other expenses of attending the university. You are not, however, even if you are found eligible for a loan, you do not have to take student loans before receiving vocational rehabilitation support for higher education. So that's the distinction between Pell Grants and loans, is that if you are offered a Pell Grant, you would have to take it before receiving VR money. If you're offered a loan, you do not have to take it before receiving VR money. So VR services can also include transportation assistance as required for training or to participate in other VR services. That could be mileage reimbursement or help with bus passes. In very rare cases, perhaps in a rural area, if the only barrier to work really was a car, if you had lined up a job, there's no public transportation, no one else who can take you to work, and you really needed a car, perhaps in that kind of rare case, VR might even be able to help you with the cost of a car. Individualized plan for employment, it has to be completed within 90 days after the eligibility determination. The client and counselor can both agree to extend time. It's reviewed at least annually and should be updated as necessary, and it can be amended at any time. So we recognize that transition age youth and young adults change their mind in what they want to pursue or what they want to do. Their interests change, and that's okay. So just because you have an independent plan for employment on one topic, you should have a counselor who understands that it's part of being transition age to have changing interests, and they should be able to revise your plan. Financial needs test. And so these govern the determination of financial needs and identify specific services that will be subject to financial needs test. And so VR services are not free for every person. And so while a person is still in the household with their parents, the household income will be looked at and there could be a contribution. The closure of the VR case is when the employment outcome has been achieved, employment is maintained for at least 90 days, and is stable, and the individual no longer needs services. The individual and the counselor should be agreeing that the individual is satisfied and doing well in the job. But know that if you're in a job and you're starting to have trouble and afraid you're going to lose your job, you can ask for a new case to be open to work on that issue. So some recent changes to talk about. So pre-employment services, kind of for the first time, the agency is supposed to spend 15% of its money for services that are called pre-employment transition services to work with schools to accomplish this. And they can include job exploration counseling, work-based learning experiences, counseling for opportunities for enrollment in transition or post-secondary educational programs, workplace readiness. And so the long-term rule was that if you really want to engage in VR services before graduation, you needed to apply for their services, have a full IPE. Now there are these other pre-employment services that they should be making available even without that whole process of the individual plan for employment. Doesn't mean, though, that you couldn't pursue an individual plan for employment with the goal of a summer job or a part-time job, especially if you're an adult student who has some flexibility in your academic schedule to accommodate a job. So supported employment, there's an extension of time for the provision of employment, of supported employment. The definition was revised to mean those ongoing supports can be provided for a period of up to 24 months. And so that's longer than it used to be. And so of course, supported employment is where you have a person, kind of job coaching and providing support in the employment setting. So another big change, and there's a lot of work happening right now on sub-minimum wage. Some of you may not know that the minimum wage law, the federal minimum wage law, has an exception for what we call sheltered workshops. So places that just employ people with disabilities who are presumed to not be able to work in other places, and they're They have to have a certain certificate to provide this kind of sub-minimum wage. And they also have to pay those people based on like a time study or other way. What we see is that there are places in Texas paying people a dime an hour for their work. Sadly, many of the people who work in sheltered workshops never even attempted vocational rehabilitation or had anyone try to get them a job in the community at a living wage, at a minimum wage, working alongside people without disabilities. They were just assumed to need to go to a sheltered work environment. And so what has changed now is that before entering a sheltered workshop, people have to at least apply for vocational rehabilitation services and be determined ineligible. They have to receive and when I say determined ineligible, there is the possibility that that VR may say, we don't think we can find employment for this person because of the nature and severity of their disability. But before coming to that determination, they should try trial work experiences. And so this shouldn't just be something based on an IQ or other arbitrary indication of the person's disability. They should receive documentation demonstrating completion of pre-employment services and the application for VR services, and be provided with documentation regarding their case file with the VR agency. And so what we're really trying to make sure is that that we're not just setting people up for an assumption that they're going to go to sub-minimum wage environments. You know, I'll take a moment here to let you know about one of the things that really raised eyebrows around sheltered work. I don't know if any of you read the media stories about Henry's turkey farm, but it was a very disturbing issue a couple years ago where this producer of turkeys that sold them to Texas grocery stores had recruited Texas men with developmental disabilities years ago to go work out of state on a turkey farm, where the turkey farm actually became their rep payee of their Social Security check, was getting paid to support the men to live there, paying them pennies on the dollar to do work that they did for decades, and using that essentially free, some might even say slavery type arrangement to the benefit of this for-profit company that produced and sold turkeys. And so that really terrible situation was litigated by the federal government. There were millions of dollars in funds from it for those gentlemen. However, it also started a bigger conversation about, are we even looking at sheltered work? And many families may have always been appreciative for a sheltered workshop that they felt just gave someone a place to go. But we have to raise our expectation on what's made available to people with disabilities in our state. And it's not enough that you have something to do. If someone is profiting off the work you're doing, you should be paid a fair wage. The purpose of vocational rehabilitation is to get people in competitive, integrated employment.
We have another question. Are
Yes,
the
ma'am.
vocational rehabilitation services different for blind children? Does the VR specialist have to obtain authorization from parent or adult child before they speak to the school about the child? So I have two separate questions there, really.
It's two separate questions. So the first is there is the Department of Blind Services, which also provides separate services. One of the benefits within the Department of Blind Services is that they will take an application for vocational rehabilitation earlier. In fact, and I'm a little nervous that I may be off on this, I believe they will take it as young as age 10. They will take it much earlier than traditional vocational rehabilitation. So you can start asking for services from the Department of Blind Services earlier. On the question on does the school district have to get consent or the VR counselor before talking, that's interesting. So the educational records are protected by FERPA is the law, which is the Federal Educational Privacy Rights Act. FERPA protects records themselves more than it protects just seeing a child or even discussing a child. So certainly a school would need consent from a parent to share any assessment, report card, diagnosis, any of the things that are in a child's records. Probably doesn't need consent from a parent for them to just be at the school, for them to provide trainings and information at the school about services. Other discussions probably get in a gray area, and I think we'd have to have more details and look at it more carefully. I think overall in the disability advocacy community, there has been a real desire to promote more VR counselors in schools, more transitional VR counselors. There's been a long thought that there hasn't been enough. They haven't been in school enough. So usually the concern we're hearing is more around the route of, my school doesn't even have one. I haven't been able to get in touch with one. I haven't been able to get one to come to my ARD meeting. So I can't say that I've personally looked into a concern about overuse of them, but it is a real issue that could be done. So we can move on to the next slide.
Another question popped up.
Okay.
If the student is under the age of 17 years of age, we have to have an authorization or consent form filled out by the parent or legal guardian before we can discuss services to take the application, as they are considered minors. I'm assuming this is a VR counselor maybe saying.
It is, so that's helpful information. Thank you, Ms. Martinez.
I work as a transition vocational rehabilitation counselor in San Antonio. So there's the answer.
Great.
Moving on.
So our client assistance program here at DisabilityRights Texas, along with many of our other teams, our primary goal is to help resolve disputes with other agencies and service providers. So our CAP team in particular helps resolve disputes with vocational rehabilitation. And one thing that's interesting about our CAP program is that the way it's funded, it specifies that that team really works at the lowest possible level to resolve disputes. So sometimes there are families who are a little nervous to contact a law firm, thinking that we're going to be, too eager to file a lawsuit or something like that. That's really not how our client assistance program operates. The client assistance program is largely former VR counselors who worked in the agencies, who work cases up the management chain to resolve disputes, make sure that people receive responses, remind counselors and others of VR's own policies in their handbook, and are able to have a lot of successes at improving the services that many of their clients receive from vocational rehabilitation. And of course, that's related to them achieving good employment outcomes. So our intake line at DisabilityRights Texas on any of these subjects is 1-800-252-9108. Our intake does make available sign language interpretation and Spanish language as well. People can also do online intakes on our website at drtx.org to request our services. I'll tell you that there's never a guarantee we can take your case. We do get more requests than we're able to handle, but we absolutely love to try to help when we can. And so don't ever hesitate to request just because you find that it might be unlikely that we could take your case. Even if we're not able to take your case, we'll try to provide you some information over the phone or some information in a short-term assistance letter, even if we're not able to offer more. There are also a tremendous amount of resources on our website on all of these topics we've discussed and many more. We also have a great Facebook page with postings of short videos about other Know Your Rights topics. So like us on Facebook, and you'll have access to more of that information. Similarly, we have a YouTube page with Know Your Rights videos on a lot of different topics that are closed caption, and many of them have sign language interpreters as well. So here are some more resources about vocational rehabilitation. This is the link to their policy manual, and also the WIOA law, which is really what changed people having to try vocational rehabilitation before going in to sheltered workshop settings. I am happy that we do have time to take questions on any of the topics we've discussed today. So, please use the Q&A feature. So I have someone who asked, who funds Disability Rights Texas? So our largest funder is the federal government, and we're funded through the federal government mainly by disability-specific grants. So we get so much funding to help people with developmental disabilities, and so much funding to help people with mental illness, and then a smaller pot of funding to help kind of everyone else, for example. We also get some that is issue specific. So we get some funding under the Help America Vote Act, just a much smaller amount, to help people with voting access issues. We also receive funding from basic civil legal services here in Texas, individual foundations, and donations from clients and others in the community. So, Ms. Martinez, our VR counselor, can tell me if I'm wrong, Susan, but my understanding is you don't have to open a VR case to access pre-employment services with VR. Am I right, Ms. Martinez? Good to hear. So, other questions?
And I'm still here. I just don't know if you lost my video feed.
I can still see you.
Oh, okay.
So someone said they're always looking for resources to assist families with guardianship because it's cost prohibitive in cases where it's desperately needed. So of course, the first thing I'm going to do is repeat, always be sure we're looking at less restrictive options. The law was changed in Texas because guardianship was so overused by people who really didn't need it, to be honest. And so we're really trying to change the way we think about who needs guardianship. I'll tell you, the only thing that's in common about the families coming to me saying they need guardianship is that someone's told them that along the way. I have families coming with really, really high functioning kids who have been told that they need guardianship. So really do think primarily about, are we talking about an individual who's not able to express their preferences? If so, and you really need to look for a guardianship for them to be able to consent to medical care, the free resources are usually the volunteer legal service organizations in each city. So for example, I live in Houston. The largest provider of free guardianships is the Houston Volunteer Lawyer Services. There's also similar agencies in all of the large cities around the state. There is a state bar hotline that can help people identify attorneys, and attorneys charge varying rates to do guardianships, and it's not the most complex area of law, and so families can also see who's willing to kind of offer the most affordable rate or work within their finances with a payment plan. Many law school clinical programs also offer free guardianship assistance. Again, I live in Houston. Both the University of Houston Law Center and South Texas College of Law offer that free assistance. And many legal service providers, for instance, here in the Houston area, Lone Star Legal Aid and the legal aids elsewhere around the state also provide assistance in that area. So,
self-advocacy.
yeah, so are there other top things besides self-advocacy that I see needed in transition plan? I think if you look at self-advocacy broadly to be on different topics, including healthcare, then I think that really is the biggest area. I also think my other big change I would like to see are more transitional programs focused on community experiences, vocational and otherwise. Because I think what we see is even districts who are trying to grow and improve their transition are still really stuck in a mindset of let's try to build the segregated, separate school or part of a school or place where we're going to work on transition. And that's really not how we want our adults with disabilities to live their life in separate, segregated spaces. And it arguably doesn't really prepare the people for transition as much as we like. So I would just really focus on what are the community experiences. There's a question here, can a person under a guardianship have his name changed? You know, that's a legal process either way, but I don't see any reason that they couldn't. It would probably require the guardian petitioning for that to happen. Name changes are often done. Many family lawyers handle name changes. I am not a family lawyer. I'm primarily a special ed lawyer, so I consult one of them to be sure, but I am aware of no obstacle that would make that a problem. Would Disability Rights Texas be involved in an appeal for someone denied Social Security benefits? And the answer to that is no. You know, Disability Rights Texas is really a civil rights organization that does a lot of discrimination-focused work. Social Security is a huge area of disability, but the law actually outlines how attorney fees work for Social Security. And they make clear that a Social Security disability appeals lawyer cannot charge an upfront fee to a client. And so we really try to prioritize our services in those areas where private attorneys don't work, don't know the law, or where they would charge a rate that would be impossible for many people to access their services. In the area of Social Security disability, Social Security insurance appeals, no one's going to have to come up with an upfront amount of money for even a private attorney. That person would get paid from a percentage of the amount that they are owed by Social Security. So for that reason, we don't do those cases. However, you can find Social Security focused attorneys who only practice that area of law, and those are usually the places you'd want to go.
Another one?
What recommendations do you have for school-based person-centered planning that you referenced earlier and related to transition planning? So person-centered planning, there are facilitators that facilitate person-centered planning processes, and those facilitators, I think the word, I don't remember the name of the credential, but they have a certificate or they've been through the training process to facilitate person-centered planning. On websites dedicated to person-centered planning, you can sometimes find a list of people in your area who facilitate those kind of plannings. Many school districts have employees in their transition department who have been through training to do that. Other school districts will potentially contract with someone who's qualified to do that. And that's a request you could make at the ARD committee meeting. So, you know, you could be in an ARD and say, hey, as part of the transition plan for my child who has a pretty significant disability and is not able to really answer your questions on this transition instrument, I would like us to have a person-centered planning process and give the district information about it. Ask, do you have anyone who could facilitate that? If the answer is no, would you consider contracting with someone? Keep in mind that in anything you ask for at an ARD committee meeting, all they can say is no, right? I mean, if they don't agree, they just say no, and that's okay. I never argue with people at an ARD committee meeting. I just say, if they're not able to do what I think is fair and good for the child, all you have to say is, please document my request in the deliberations and give me my prior written notice. And really, I promise that moves them towards your position more than any other argument you could make. Is just say, I understand your position. Please document my request in the deliberations and know that I'm going to have to disagree at today's ARD.
Okay, we're pretty close to the end. I think that's the last question, right?
Okay.
So thank you so much, Dustin, for joining us today. I'd like to also thank Texas Closed Captioning for providing our captioning. We will send the captioning transcript to participants in case they want to review any of the information provided in the session today. So thanks again for joining us today, and we will see you next time.
Okay, thank you very much.
Thank you, Kristen. Bye-bye.